ಮಾತಾಡಿ ಕೇಳಿಸುತ್ತೆ ಮಾತಾಡಿ.
Agarwal sir, can you hear us?
Can you hear me?
Yes, sir. You are audible, sir.
Okay, okay. Thank you so much.
What is the order?
I will go to the High Court only after half an hour.
Yes, sir.
I'll join some other VC in the other High Courts.
Right, sir.
Okay. Thank you.
ಸರ್ ಏನಾದ್ರು ಲೈವ್ ಇದು ಮಾಡಬೇಕಂದ್ರೆ ಆಡಿಯೋ ಇದು ಮಾಡಿ ಲೈವ್ ಸ್ಟಾಪ್ ಮಾಡಿ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲೇ ಡಿಲೀಟ್ ಏನು ಮಾಡಲಿಲ್ಲ ಏನು ಮಾಡಬೇಡಿ ಅಂದರೆ ಲೈವ್ದು ಲಾಸ್ಟಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿ
ಮೊದಲೇ ಏನು ಮಾಡಲ್ಲ
ಮಾಡಿಬಿಡಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮತ್ತೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಇವಾಗ ಲೈವ್ ಬರ್ತಾ ಇದೆ ಸ್ಟಾಪ್ ಮಾಡ್ತೀವಿ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀವಿ
ಹೊರಟೋಗುತ್ತೆ
ಹಳೇದೆಲ್ಲ ಹೊರಟೋಗುತ್ತೆ ಇವಾಗಿಂದ ಬರುತ್ತೆ
ಮುಟ್ಟದೇ ಇಲ್ಲ
ಅದು ಲೈವ್ ಅದೊಂದು ಇದು ಮಾಡಿ
ಲೈವ್ ಬಂದ್ರೆ ಸರಿ
ಫೋನ್ ಮಾಡಿ ಅವ್ರು ಕೋರ್ಟ್ ಯಾವ ಕೋರ್ಟ್ ಓ7
ಮೇಡಮ್ ಅಯ್ಯೋ ಪಾಪ ಅವ್ರಿಗೆ
ತಗೊಂಡ್ಬಿಟ್ಟು
ಎಷ್ಟು ದಿವಸ
State of birth. State of birth. State of birth.
Hello, it's,
further hearing?
hello, it's Senior Advocate Agarwal is online for me.
May I please, my lords?
Just 1 minute.
Please, Secretary.
Further hearing?
Now you are arguing on whose behalf?
My lords, I appear for respondent number 4 in this writ appeal. I was one of the writ petitioners earlier. One Mr. Syed Rahman.
Writ petitioner number 4, my lord, Syed Baligur Rahman. R4 in one and R7 in the other.
At page number 9, your lordships will get.
Petition number 4.
Yes, my lord.
So
Before
Yes, yes.
Yes, yes. my lord.
before the senior counsel commences,
Yes.
I may be permitted to file this memo, my lord. This is regarding the latest judgment of the Honorable Supreme Court. After the judgment, the Honorable Rule Committee has decided to form a subcommittee to go into these aspects. So accordingly, Honorable Judge of this, retired Judge of this Honorable Court, and a district judge, a committee has been constituted
Yes.
to submit a report. Just bringing it to the notice of your lordship.
Yes. Yes, Mr.
Well,
Gaurav.
just for clarity, my name figures at serial number 380 in the revised seniority list, which is now
380.
380 in the revised seniority list, annexure N, which is at page 573 of the paper book. We are sailing in the same boat as all the grievance of all the writ petitioners were identical. Let's have page 573.
Yes.
This direct recruitment which took place with lordships have page 573 minutes. Volume 3 minutes.
Yes.
Yes. Lordships may begin with serial number 373 minutes. This is one batch of direct. This is a batch of direct recruitment which took place on 1st February 2016 minutes. And I figure it now 380 minutes. Grievance of all of the present direct recruitments are identical. So I am similarly identically situated. Because while the lordships are on this annexure, lordships will just bear with me and just take that the earlier direct recruitment, to the best of my reading, took place on 8/6/15, which is at page 331. At serial number 331, page 570. Page 570, your lordships will get serial number 330. There are 5 direct recruits, Milords, 330 to 334.
Three 32.
334 minutes. After that, Milos, that happened on 8/6/15. Now, Milos, the subsequent promotions are from 26 August 15. This is the same batch, though the date may differ, but this is the same batch of promotions which have taken place, which starts from 335 to serial number 372. 335 onwards, your lordships will see. Just to give an example, Mr. Gurumurthy, promotion, your lordships will see. And this list goes up to serial number 372. "38 officers are promoted, Milos, in this promotion which took place in August 15 prior to my appointment. And our contention primarily is that largely this promotion, subject to determination of actual cadre strength and quota, which is still now engaging your lordship's attention, are largely in excess of the promotee quota. Largely, although we have also, just for completeness, it's my duty to point out that we have actually also made the previous promotees a party to our writ petition, Milos. And that serial number, Milos, your lordships will just take a note, begins largely from serial number, if I'm not mistaken, 305, subject to, serial number 3, just give me 1 second. Serial number 314, subject to correction. Sorry, 288, Milos. 288. Lordships will have page 567. Your lordships will see there is a large number of promotions which have taken on 1/4/2015. Lordships have serial number 288, Milos.
Yes.
288 onwards, your lordships will see the noting to 1/4/15. Promotion. It goes on, Milos, till serial number 329. So these are the 4 promotions and 2 promotions and 2 direct recruitments, which are essentially, Milos, concerned with, your lordships are concerned with. And they're all respondents. So the direct recruitment, so am I clear to your lordships?
Yes.
The direct recruitments of my prior batch, which is 8/6/15 batch, where 4 officers were directly appointed, is not under challenge. They are admittedly within their quota. The only question is how many of the promotees are beyond the quota. That's the only question which now engages your lordship's attention. If at all, if we are correct. And if your lordships hold, and once your lordships comes to the conclusion, as we'll persuade your lordships to, that they are beyond to quota, to the extent they are beyond the quota, they would have to reckon their seniority below me, below this batch of 2016 batch of 1/2/2016. Why this litigation happens is because there is absolute lack of clarity as to what is the cadre strength of the district judges in the higher judicial service. That's why the litigation has come. Otherwise, this litigation wouldn't have come and your lordships wouldn't have been troubled at all. And when your lordships today are sitting in a full bench, it is very important that lordships lay down the exact basis on which this cadre strength has to be determined, so that future litigation is avoided and there is absolute certainty that yes, this is the cadre strength of the higher judicial service, which is important for two very good reasons, Millers. One, to determine the quota between direct recruits and promotees. And secondly, now when your lordships will implementing the new judgment of the Honorable Supreme Court in All India Judges case, it is all the more important that your lordships are as a full bench and as we are a part of the system, because we as advocates think we are part of the system, that your lordship should ensure that there is certainty and there is no ad hocism in this kind of litigation, and this litigation doesn't come. That's why, Milos, I'm addressing in that light, Milos, to your lordship. Now, Milos, so I have 3 submissions to make, and I will not take more than 10 to 15 minutes, so that, Milos, your lordships can proceed further. I have written down those submissions. I'll make it a part of my written submissions at the end. Number 1, lordships would have to lay down tests as to when a post is created in a cadre. In this case, we are concerned with judicial service. It can be limited to the judicial service because High Court is involved in creation of posts also. So, Milos, your lordships will have to, according to us, this is our respectful submission. Your lordships will, our submission is that a post is created when the state government and the High Court agree that yes, there is a requirement of an officer, as a result of which I now hereby approve that a post is to be created in a higher judicial service. That's the first submission, Milos, I have. Because it is not a individual decision by the High Court alone which will result in the creation of a post. So both the constitutional bodies, the state government and the High Court, application of mind, discussion, resulting in creation of the post. Number 1. Number 2, the post has to be created by the state government. As far as the higher judicial service is concerned, I respectfully submit that though we are a constitutional court, Milos, ultimately the state government will have to say, yes, I have created a post on the request of the High Court. All financial compliances are done. The person who is appointed will be now a part of the judicial service if that post is created. This kind of, Milos, approach has to be adopted according to us so that there is certainty in the cadre strength of the higher judicial service. Number 3rd, Milos, the High Court should be mandated to publish this cadre strength and along with the consultation of the state government. Whenever there is an increase, I think, Milos, it's our duty to prevent future litigation to say, yes, with effect from 1st January, say 2027, the cadre strength of either civil judge senior division, civil judge junior division, higher judicial service has been increased by 4 posts, 5 posts, 7 posts or 10 posts. I think it's very important, Milos. Otherwise, Milos, this litigation will continue. So your lordship should lay down that this is the methodology the government and the High Court should adopt to notify what should be the cadre strength for the higher judicial or lower judicial, district judiciary. Because these are my submissions on the cadre strength, Milos. Now, Milos, lordships have heard learned senior on the certain posts which the High Court has constituted as cadre posts. Lordships have already observed that this kind of creation by one post or the other by a letter or an order or by understanding may not be the correct methodology to create a cadre post. A post in the cadre. Because that your lordships may consider. I am not requesting your lordships to say that this is not a cadre post or this is a cadre post. Lordships may leave it for determination after laying down principles. Once those principles your lordships lay down, registry will calculate the cadre strength. Then, Milos, the second question will arise. So I am going to the second submission now. That this is the methodology. I am humbly requesting your lordships, subject to hearing the other side, hearing the High Court, hearing the state government, so that these disputes don't arise in the future. The second important point is, now when the court is sitting, and I'm making the second submission, and that, your lordships, we had the learned single judge's order, I was not there, but before division bench, this was a pertinent question which I had placed for the honorable division bench's consideration. There are two sets of promotions which have taken place, Millers. One is roughly around 1st of April 2015, and one is on 29th of August 2015. These are the two promotions in question, Millers, which are now impugned, not in the terms of, I'm not saying that those promotions are bad in law. The only question is whether they are beyond the quota. That's all. So just to clarify, Millers, a submission was made that if submissions are beyond the quota, the only consequence is seniority. It is not my case that they should be demoted, that they were wrongly promoted. This is not my case. My only contention is, if the promotion your lordships find is beyond quota, they have to be pushed down because they can't occupy posts which are meant for direct recruits. That's my simple submission. So my going back to the main point, Manoj, what my simple submission was, that when the Honorable High Court decides to promote officers from the senior judge civil senior division in April of 15 and August of 15, was there an application of mind to what was the quota for the promotees and what was the quota of direct recruit? Because we are not able to get any material to show that this was done when these promotions were made. So normally, suppose if I am an employer and I want to promote people, I will be asking the first question, how many total posts I have, how many are promotee posts, how many are occupied by the promotees. Because that exercise, we don't have access to the records of the High Court. If that exercise has been done or not is the second submission. Whenever the High Court promotes or whenever the High Court does direct recruitment, there should be application of mind. And therefore the learned single judge said that perhaps this is required to be redone. And therefore we are supporting the learned single judge's the judgment that it appears that this exercise was perhaps not done, and the promotions were made of the promotees.
The single judge has not been as clear as you are.
No, Milos, I am very grateful, but this appears to be. I was not there before the single judge, but I would believe, Milos, whenever the full court, and Milos, this is a conjoint exercise between the High Court and the state government. The High Court will say, I believe these officers should be promoted. I have X number of posts, say 100 posts in the cadre. My 65% are promotees, 35 are already working. Therefore, I am promoting these 30 officers. This is a simple mechanism, Milos, which needs to be followed so that in future there is no litigation, Milos. I am not concerned. One way or the other, your lordships will decide this question. But going forward, Milos, I think it's very, very important that the High Court publishes the cadre strength on the 1st January of say 2027. It says that this is the vacancy being occupied. I am calling promotions. I am promoting on the promotee quota. There may be more officers available, but you don't have posts. Now I'll go to the on the other flip side. Because I have seen, I have represented all sides, district promotees, high courts, governments. Sometimes, what happens, direct recruitments get delayed. It has happened in my state. Say I'm from Bihar, it happens in my state. The appointments are done by the selection is done by the Public Service Commission. Now there was a question paper leak, and therefore for entire 1.5 years, the whole exercise had to be redone. So the High Court may promote people because it needs officer in the higher judicial services. So your lordships will promote a person, and sometimes it may happen that it is in excess of quota. That doesn't mean that appointment is bad in law. It only means that as and when the direct recruitment is made, that person's seniority will make way for the direct recruit because he was actually occupying a direct recruit post. That's the only simple submission I have on this. So this is my second submission, Millets.
Yes.
And my request to your lordships in the third submission is that this entire exercise should be done and placed before your lordships for consideration. Lordships should examine whether whatever your lordships lay down has been followed by the High Court or not, so that lordships have heard extensive arguments. I have followed 6 days of arguments or 6 and 7 days of arguments, and your lordships have heard extensive argument. It is important that the High Court is able to with clarity give your lordships that this is the sanction post, this is what was done, this is the excess, this was not the excess, and therefore what the High Court done is correct or incorrect, so that the litigation can come to an end. This is very important, because this seniority, sorry.
Yes.
Now, I have only 3 decisions. I will not read them. I will just cite them, give the para number and the proposition I want to place before your lordship. That's all. And I'm done, I'm subject to questions from your lordship. The first judgment, if I can, refer, I don't think so, the copies would be available. So if your lordships can pardon me, I'll just give the citation and the para number and the proposition. Is that permissible?
It's available,
Yes.
sir.
Yes, okay.
I'll just place it here.
Yes. So first proposition, I had placed a submission that creation of post is essentially a government function. For that, I have one decision, that is 2021, volume 20 SCC 290. Para 13, last 4 lines. I'm just reading the relevant part, I'm not, so that I'm sure lordships have heard all submissions. Just to supplement, and that's it. And it's not my endeavor to take a minute more. Last 4 lines of para 13. That's all that is relevant.
You can take your time.
No, I know, but it's just that this is all that is there, I don't want to keep repeating. Sir has already argued everything. Even the creation and or sanction, lordships have those are the last 4 lines, It arises in different context about regularization when a person is not working on any post. But what is important is even the creation and or sanction of the post is also the sole prerogative of the government. And the High Court, in exercise of power under 226, cannot issue mandamus and to direct to create and sanction the posts. So my humble submissions for your lordship's kind consideration is that under the separation of powers and the cooperative institution we have, where the High Court and the state government work together to ensure that justice dispensation is done, the finances, etc., come from the government. The High Court will engage with the government, and there will be a collaborative effort to say, yes, we need 100 district judges to perform the judicial functions. And the state government will say, I agree with you, or I disagree with you, or I'll agree with 90 of the judges and not 100. And those posts are created. Those are then becoming a part of the cadre strength of the higher judicial service. So, because according to me, this exercise is something which your lordships will lay down, that it's for the government actually with the High Court to consider what was the cadre strength which was available to the High Court on 1/4/15. Because that date is now cast in stone, because this is the date on which the first batch of promotions are made. So the essential question is on 1-4-15, what was the cadre strength? How many promotees were actually functioning on 1-4-15? And whether the promotions were in excess of that promotee quota. Because this is the question to be answered according to me. The second question will be, suppose now your lordships, the High Court tells your lordships that yes, on 1-4-15, I had 65 sanctioned posts, 30 were working. I have promoted these 32. They were within their quota. So those promotions are held to be valid by your lordships. I have no grievance. Then a direct recruitment takes place in 2015. There is nobody's case that they are beyond the quota. Then, Milos, in August 2015, again 30 officers are promoted. The second, this again at this point of time, again an exercise will have to be done and should have been done and ought to have been done, which in our respectful submission has not been done, is how many vacancies are available in the promotee quota. Now suppose, sorry, Milos.
Now,
Yes, Milos.
we'll start the questioning after you finish.
Whenever, Milos, I'm almost done, Milos. I had just 2 more judgments and I'm completed, Milos. I'll just put
Finish
those.
it. We have
Yes,
some queries.
exactly. I'll just finish this. The 2 judgments, one is a division bench of Karnataka High Court. Ma'am, you have a copy of that judgment for lordships?
Yes, sir. Just placing it.
Yes, ma'am. Para 8 of that judgment, Milos. Here. Sir, I have just 2 more judgments, Milos, and I'm done, Milos. Para 8. May I have permission to read?
Yes.
From the aforesaid judgment, it is clear that when the statute provides for filling up of vacancies by promotion as well as direct recruitment on 50-50 ratio, the vacancies have to be filled up strictly according to the rules. It is settled law that prescription of quota for different posts is constitutionally valid. If promotions are made to vacancies in excess of the promotional quota, the promotions may not be totally illegal, but would be irregular. The promotees cannot claim any right to hold the promotional post unless the vacancies fall within their quota. If the promotees occupy any vacancies which are within the quota of direct recruits, when the direct recruitment takes place, the direct recruits will occupy the vacancies within their quota. Promotees who were occupying the vacancies within the quota of direct recruits will either be reverted or they will be absorbed with vacancies within their quota. When a promotee is placed in charge or promoted temporarily to the post to be occupied by direct recruitee, he is not born in the said cadre, because once a direct recruit is placed in the said post, he has to make way for direct recruitment. The Karnataka, Milos, the rest is not relevant. It deals with the Karnataka rules, Milos. So, Milos, I just wanted to complete. So, Milos, the question is that when I was promoted on 1-16, that is the relevant question. When I was appointed, not promoted, I was appointed by direct recruitment on 1-16. How many people were occupying the direct recruitment quota? To that extent, Milos, those will have to be pushed down. And as and when future vacancies arose, they will get their seniority. That's my simple submission. Now, Milos, the last judgment I have, it almost reiterates this push down theory, Milos, which I just submitted for your lordship's consideration. Just have with me this one paragraph, and then I'm Milos, whatever lordships 2006 volume 10 SCC 346. Para 30 of this minutes. Because facts are of these cases are very different. There is no point in me trying to draw correlation in facts, Millets. Last line at the reported page, Millets. Page 359 of the report, para 30, last line, Millets. It is well settled, Millets. Lordships have that?
Yes.
It is well settled that promotion in excess of quota makes an employee an ad hoc employee, and seniority cannot be given to such employees on the basis of ad hoc promotion. This was observed by this court in a series of cases. In Keshav Chandra Joshi versus Union of India, this court observed it is notorious that confirmation of an employee in a substantive post would take place long years after retirement, and an employee is to be considered for promotion on regular basis to a higher post if she is an approved probationer in the substantive post. An officer appointed by promotion in accordance with the rules and within quota and on declaration of proposal is entitled to reckon his seniority from the date of promotion, and the entire length of service, though initially temporary, shall be counted for seniority. Ad hoc or fortuitous appointees on a temporary or stopgap basis cannot be taken account for the purpose of seniority, even if the appointee was subsequently qualified to hold the post on a regular basis. To give benefit of such service would be contrary to equality enshrined in Article 14 and 16 of the Constitution, as unequals would be treated as equals. When promotion is outside the quota, the seniority would be reckoned from the date of vacancy within the quota, rendering the previous service fortuitous. The previous promotion would be regular only from the date of vacancy within the quota, and seniority should be counted from that date and not from the date of his earlier promotion or subsequent confirmation. In order to justice to promotees, it would not be proper to do injustice to direct recruits. The rule of quota being a statutory one, it must be strictly implemented, and it is impermissible for the authorities concerned to deviate from the rule due to administrative exigency or expediency. The result of pushing down the promotees appointed in excess of the quota may work out hardship, but it is unavoidable, and any construction otherwise would be illegal, nullifying the force of statutory rules, and would offend Article 14 and 16. Therefore, the rules must be carefully applied in such a manner as not to violate the rules or equality ensured under Article 14. This court interpreted that equity is an integral part of Article 14, so every attempt should be made to minimize as far as possible inequity. Disparity is inherent in the system of working out integration of employees drawn from different sources who have legitimate aspiration to reach higher echelons of service. A feeling of hardship to one or hard-burning to either would be avoided. At the same time, equality is accorded to all employees. Millers, I'll stop here. So this is my respectful submission, Millers, on this.
The quota system
Millers.
is on the basis of entirety of the cadre strength and not vacancy.
Yes, Millers.
But the pleadings before the single judge
Yes, Millers.
appear to indicate
Yes.
the case is made out regarding vacancy in the what they refer to as increased cadre strength of 139 posts.
Yes, Millers.
So the case that is there before the court appears to be a vacancy based and not cadre based.
Millers. May I respond to that, Millers? Millers, your lordships rightly noticed in the previous hearing that apart from two notifications of 2001 and one derivative notification of 2010, there is absolutely no record which is available as to what is the cadre strength of the district judges. Now, Millers, when we challenge Millers, we see a large, Millers, please consider our writ petition, Millers. We joined in 2016 in February. When the seniority list is published, Millers, there was already a draft seniority list earlier, which was, we were not party because we were not even appointed on that day. When the seniority list is published, we find that we are below nearly 60-70 promotees who are promoted on 1st April 15 and August 15. So we say that, look here, we believe that on a limited understanding of what should be the quota, what is the number of promotees functioning, and the actual promotions made in April and August 15, they are beyond the quota, meaning thereby there were not enough vacancies in their own quota. So because it has got interlinked to the total cadre strength and the vacancy. Because it is very difficult. It's actually at some points time simple, at the point time tough. You have to determine the promotee quota based on the cadre strength. But whether the promotions are within the quota or not will depend on the vacancies. Now that vacancy itself, Milods, for seniority has another third element. You have to determine the vacancy on my appointment. They may be, I'm giving an example, they may be beyond the quota. Suppose 4 officers are beyond the quota in August 15, Milods, when they are appointed. But by the time I get appointed, there were 4 vacancies which arose because of superannuation. They will be then treated senior to me because the vacancy has arisen prior to my appointment. So even though they were beyond the quota in August 15 when they were promoted, by the time I got appointed by direct recruitment, there were sufficient vacancies to accommodate them. So Milos, I will not be able to challenge. So in absence of this clarity is exactly the result of this litigation, Milos. That's exactly the submission I made before your lordships. That's why it has got intertwined with number of posts and number of vacancies.
Theoretically is right. First you bring them now.
The only prima facie view is that
Yes.
perhaps the judges could have made some more homework before filing the writ petition. One. Now
Well, the
coming to
lawyers
No, no,
representing the
no, the
lawyers
litigants.
representing those
The,
judges.
the judges were the litigants.
Yes,
So,
Milos.
so we are saying that the
Yes.
judges could have made
Yes.
little more homework.
Yes,
in terms
lordships
of
are right.
the
I agree
the
with
only,
you.
the only view, only reason being that
Yes.
in case of the seniority matters,
Yes.
pleadings will have to state that
Absolutely.
this is the
Absolutely.
cadre and that is the premise.
Yes,
Now,
and
that said,
yes, sorry, Milos. Sorry
that's-
to interrupt.
yes, yes.
No,
Yes.
so your lordships are saying something.
Now, the second impression that we had on reading of the pleading is an attempt to reopen what was settled in the previous division bench by
Yes.
again going back to
Yes.
fast track court judges seniority versus. So we prima facie the impression is that you can't go beyond the division bench judgment whether it is right or wrong. Now, as on the date of the division bench having stated that the promotees are entitled to be placed earlier to 2009 when the substantive vacancies arose, right or wrong, there ends the matter. Now, once the promotees have been conferred with certain rights by virtue of the order of the division bench, at this point of time, we can't reopen the 2012 seniority list. Now, there are two parts of it. One is your argument that the point of inquiry would be in August and the preceding dates of promotion.
Yes,
And
Milos.
from then, that could be the reference point, is the case that you have made out.
Yes.
But if you look at the pleadings and the arguments advanced by
Yes.
the other writ petitioners, they appear to try to reopen the earlier division bench and go beyond these two dates. What do you say regarding such as?
I think, Milos, my respectful submission to your lordships is, Milos, in law, what your lordships prima facie observed, that a judgment of this honorable court has attained finality qua the rights which are available to the ad hoc judges by a division bench. That is ultimately, this is a judgment which is of the court. Because whether I like it or not, because it's not for me to comment on this. The Supreme Court has taken a different view in the matter. And when your lordships are sitting in full bench without disturbing any of the available Milord's benefits which have gone, be it the pay, be it the promotion, if your lordships find that today when your lordships, the seniority list has to be reworked, because how that adjustment has to take place, because we would probably be treading on something which may violate a Supreme Court decision, because which under Article 141 may be binding. So while your lordships are entitled to fully protect whatever benefits have gone to the ad hoc judges, because even a wrong judgment is binding on parties. Suppose after 10 years, the law is reversed. The review is also not maintainable under Order 47, because a subsequent declaration of law is not a ground to review also. So, Milords, I would respectfully submit that, Milords, this is only a question of adjustment we are talking about, Milords. It's not a question, and it is only a notional adjustment because everybody has retired. So it is only a question of saying that it's a notional adjustment which has to be in compliance with the highest court's judgment and in accordance with our rules of 83, in accordance with the judgments of this court, which says how the vacancies in the promotee quota and the direct recruitment quota have to be filled. Please take an overall view of the matter, Milords. Please look at the future, Milords. When we as lawyers argue, we argue a case. When your lordships decide, Milords, lordships have to look to the future. So please look at the future so that this kind of disputes are removed to the extent possible by saying this is how it should have been done. We accept what has happened, but this would have been the correct position of law. Milords, to correct an error is a virtue, Milords, according to me. If I make a mistake and your lordship say, Gaurav, you have made a mistake, if I correct it, it's a virtue according to me. That's what my respectful submission is, Milords.
Only difficulty would be,
yes, Milords,
because we have not made up our mind, we are
yes,
open. That what was challenged before the division bench was the seniority list of 2012.
Yes, Milords.
And there the court granted some benefits to the promotees.
Yes, Milords.
Pursuant to which the seniority list was directed to be reworked.
Correct, Milords.
So the consequence of the direction of reworking of the seniority list,
yes,
now cannot be undone in that sense, that those who had got some benefit under the 2013 writ appeal,
yes,
would be at the receiving end.
Milords, that's why I said please protect those benefits. I have no difficulty, Milords. But the benefit, it can't be that it recurs into a problem and results in violation in the future. When your lordships say that this should be the law as per Supreme Court, your lordships are not taking away any benefit. I don't think so that will happen, Milords. Therefore, I said, Milords, that was my submission, Milords. Please work out, please ensure that it is settled, rather than, Milords, please direct the High Court to do the exercise. Come back to your lordships, because your lordships have now this kind of hearing, Milords. In my limited experience, your lordships have seen a wide range of rules, all the judgments. Now, your lordships, whatever your lordships lay down, should be final as far as your lordships are concerned, and ensure that the judgments are, the seniority list is in compliance with what your lordships lay down. Because according to me, this can be protected. Because I have no difficulty with that. Your lordships will clearly say whatever benefits have gone should be protected. But while making future seniority lists, if we keep relying on the same mistake again and again, Milords, perhaps, Milords, it may result in a situation where a wrong a Supreme Court judgment which lays down the correct law is being disregarded for future benefit, not for the people who have already got the benefit.
To recount the finding.
years back, we have to look at as on 2015. Okay. So because of the question we asked, we have gone to 2015, sorted on this case. We will look at what is there as on 2017. Pushing down. Your 2012 seniority list is much prior to that.
Now, a supplementary question.
Yes, Milots, please, Milots.
Now the Apex Court has said you implement the 4-point roster.
Yes, Milots.
And
Correct.
it has given 3 months time.
Right, Milots.
Now let us now the background in which this direction must be looked into
Yes.
is that since 2011 the High Court, rightly or wrongly, has failed in taking note of the direction of the Supreme Court insofar as roster point.
Correct, Milots.
That's for the High Court to now. I mean, of course, they don't have a stand on that. But
Yes.
in the if we were to now, there is some committee set up to look
Yes.
into this 4-point, etc. Before this 4-point roster is implemented, now there has to be a reworking in terms of the new ratio.
Yes.
Of what is the cadre strength, what
Yes.
is the quota strength,
Yes.
and then see how you are going to reconcile the imbalance before you start the roster,
Right.
or you plot the roster from point 0.
Right.
The other way of implementing this
Right.
new roster that has come in now is to, after finding out the quota in terms of the new proportion that is fixed, you plot the quota from post 0.
Right,
And then you come up.
Right.
And after you come to the last point, then you will have to reconcile the deficits in the each of the cadre.
Yes.
And then you will have to do the roster point. And
Yes.
after the roster point, everything is settled, then it should be only replacement theory.
Right. Or fresh recruitment or fresh promotions if you are deficient.
Correct.
Suppose at the roster point you find that there is one promotee missing, then you advertise or call for applications for direct recruitment if DR posts are vacant.
Correct. Now
One
the only
minute.
yes.
No.
So now the only prima facie observation, though we have not made up our mind,
Milot.
that though you may have had a grievance,
Yes.
your pleadings and manner of conduct of litigation
Yes.
may not be up to the mark. That we will anyhow examine.
Yes, please
Now,
do.
what relief that you are seeking
Yes.
of redoing it at this point of time,
Yes.
pleadings appear to be slightly wanting. The
So,
case
Manoj,
and
I must frankly admit I did not prepare for that. I will look into it, and since your lordships, if I feel there is something more I can add on that pleadings bit, I'll look into it and research. Please give me that 5-minute liberty, some point of time, to address your lordships or give it in my written submissions. Because to be very frank, Manoj, I did not expect this question, so I'll look into. Yes.
At para 5.3 onwards.
Yes, Manoj. So at page the writ petition, Manoj.
Just have a look at it.
Yes, Manoj. That is actually my learned senior had read out para 5.6 at page 172.
Just only.
Lordships have, I think, 172 in mind, subject to correction from the other side.
169.
Yes.
No.
Yes.
170.
See
Yes.
that reference to 139.
Yes. So can I read from 5.3 onwards, Milos? Para 170.
Yes. So what my observation is.
Yes, Milos.
That this pointed reference in para 5.6.
Para 5.6. Yes, Milos.
Goes to
Yes.
the 139 has increased in cadre strength.
Yes,
and promotion. That's a wrong premise. It cannot be vacancy based. It must be the strength of the entire cadre. And you
Yes.
can't work the quota insofar as only this proportion of 139. Sans this,
Yes.
the pleadings doesn't rest on what is the cadre, entirety of cadre strength, etc. So one view, I'm
Yes.
saying, though we have not made up our mind, is that there's a lot of deficiencies in the pleadings, though you may have a grievance. So on the basis of such such pleadings, whether we should reopen this is something we are still considering.
So Lordship will just have the, I'll address your Lordships on this. I'll prepare and address your Lordships on this. And Sir is there in court now, so I mean, Sir can also assist. But please have page 170 onwards, please.
Yes.
Para 5.3. In the impugned seniority list, the persons who are juniors to petitioners have been placed above. It is submitted that no retrospective seniority can be given. So what your Lordships are saying, it is not absolutely crystal clear is what your Lordships have in mind. Is that the correct understanding of your Lordship's question?
5.6 is vacancy based.
Now just have a look at 5.6. A perusal of the impugned final seniority will reveal that 139 officers are said to be accommodated, adjusted in respect of post as a result of increase in cadre strength. That is serial number so and so. The said posts which arose as a result of cadre strength have to be earmarked as per the quota prescribed under the rules for direct recruit promotees and promotees by way of competitive exam. It is to be mentioned here that in respect of some of the promotees, there is no mention of date of which cadre strength is increased. However, even assuming there is an increase in cadre by 139 posts, only 90 posts are available under 65% promotional quota in respect of the post in the cadre of district judges have increased. However, the impugned seniority list reveal that 114 persons have been promoted against the 65% quota. Though only 90 could have been earmarked for promotees, these 114s are adjusted against vacancies under the head in cadre strength and shown as serial number so and so. The vacancies have not been classified among the three sources of recruitment to the post of district judges after making block period commencing from the date of 83 rules. Thus, the respondent 13 to 82 who are promoted in excess of 65% quota meant for promotees cannot be given seniority, though they have been promoted earlier, and they have to be pushed down and given seniority from the date on which vacancy arose. Because actually it shows that we had, because why this Lordships will recollect, which learned senior pointed out. Sorry.
Even they are saying that 100 posts were promoted. You would have promoted 90. Out of 139. This 1 forward is relating to 139, but the increase when the entire is given. Increase just the bleeding and not the entire bleeding. So itself is where the foundation will be down. He is saying that
Yes.
Because why this Lordships will notice the difference, which I think Learned Senior has pointed out even on the last date. What was before us when we filed the writ was the seniority list at annexure A, Milos, at page 184. Lordships will have page 184.
Yes.
Now, Milos, I will come to the immediate reason where we calculated this based on the why we challenged this seniority list was that we categorically stated that what promotions you have made. Lordship may just come to 218. Serial number 287. Lordships have that?
Yes.
Now, Lordships will keep this in mind. This the learned judicial officer, Miss Naveen Kumari, is promoted on 1/4/2015. Lordships have that date of promotion is there, no difficulty. Now, please have the next column. Due to increase in cadre strength on 1/1/14. This is what the High Court told us when the seniority list was published. Lordships, get that, Milos?
Yes.
Now, Milos, 1/1/14, we don't know even the date on there's no notification which is available to us of 1/1/14. But the High Court in his seniority list says there is an increase in cadre strength on 1/1/14. So the first question, Milos, I'll ask is, where is this cadre strength increase? Please show me. But assume that to be so, Milos, that there is an increase. Your Lordships will find on the right column, right from serial 287 till serial number, Milos, till the immediate seniors are promoted. It is mentioned that either there is an increase of cadre strength or there is a retirement of an incumbent. Lordships will see each one of them. I can take through one or two of them for your Lordship so that I don't take much of your Lordship's time. Lordship may see serial number 287. After 287, your Lordships may see serial number 290. 290 due to retirement. Then 291 due to retirement. Then Milos 293 due to increase in cadre strength. So our contention was very clear that you are saying that you are making these promotions because there is an increase in cadre strength. But when there is an increase in cadre strength, there is a corresponding increase in the quota for DR and the corresponding increase in the quota for promotees. Now that bifurcation is not forthcoming. So I take it that there is a 139 increase. You could have only promoted 90 officers, but you have promoted 114. Therefore, the officers in excess have to be pushed down. Because that is the sum and substance of 5.6.
Yes.
Now, the High Court, in his reply said, we have given seniority from the date of promotion or direct recruitment. That's a simple reply of the High Court. High Court doesn't address the question as to what is the manner in which the cadre strength increased, what was the vacancy on 1/4/15, what was the vacancy in the promotee cadre, what was the vacancy in the DR cadre. After having this, High Court could have simply said, sir, you are wrong. The total number of cadre strength is X. The promotees are Y and they are within their quota. This reply came for the first time before the division bench, when a memo was filed explaining how the High Court has calculated the quota, the cadre strength. And that learned seniors from both sides have addressed why that is the correct assessment or the wrong assessment. So therefore, I started by submission. My first submission was, what is the test to determine the cadre strength? And especially for a higher judicial service or any judicial service, it creates a little complicated situation because the High Court and the state government both are involved. So the High Court must actually come up frankly to say what is the basis on which they are saying that the government has agreed to the increase of cadre strength, which your lordships will not find at all. So once your lordships lay down the principles on which the cadre strength has to be determined, all this will work itself out. So according to me, from a prima facie reading, subject to more research, these pleadings are sufficient because I am only concerned with the promotions which are made in April of 15 and August of 15. If I am able to show from this very document that you have increased the cadre strength, but what happened to the direct recruitment quota? Then the High Court merely says, sorry, I'm not going to tell you, I'm only gone by the date of promotion. So the learned single just said that rightly according to us, that the seniority list is wrongly prepared. So you redo the exercise. So for that, according to me, there is sufficient material and pleadings, but I'll still research and come back to you.
The next question is,
yes,
now, how far back are we going now at this point of time? If
yes,
if admittedly all this dates back to sometime in 2014, it starts when this
yes.
increase in cadre strength appears 139 posts.
Yes.
Now, how far are we going to go back to adjust when many of them now have done their duties as principal district judges, have gone home, or some of them are along with us?
Frankly
some of them are along with us.
Frankly speaking, appearing for a judicial officer is a very tough job, for a lawyer. It's a tough job. We are part of the system. We are so much so much part that our submissions have to be perfectly balanced. We are only seeking guidance from your lordships that it is not adversarial at all. It is not I want somebody to go down, I want to come up. No, it is not our case. Our only case is simply work out what was the cadre strength, how much was the promotee quota, which were the promotees who were accommodated, which were the direct recruits who were accommodated, and give.
No, we appreciate the tenor of forthright submission.
Yes,
and we will keep it in mind. Let us see.
Because it's tough, I understand, and especially as a part of the system, nobody will like to be a part of the system. I'm sure my clients would like to say let's move on, but perhaps it may create a little bit of heartburn if there are large number of people ahead of you, and you find that perhaps there are far in excess, and this is exactly, Milos, which All India Judges judgment, if your lordships read, I think it's a 17th November or 19th November, the date escapes my immediate recollection. The application was made by the learned amicus curiae, Mr. Bhatnagar.
Yes,
He
yes.
made an application before the court. Sir, this is happening that large number of promotees are not making it to even the post of PDJs. When the Supreme Court called for information, it was not able to find that this was the correct picture everywhere. Therefore, the Supreme Court said, look here, what has happened in the past, and therefore I want to actually address your lordships on the future part also. Please permit me that indulgence. The Supreme Court said, look here, I don't want to disturb what is happening in the past. But to maintain an equilibrium between promotees and direct recruitments, we believe, and this is a belief, this is because in future, how these quotas have changed, lordships have seen. Earlier it was 10%, 25%, then it was made 10%, then again 25%. I'm talking about limited competitive examination. Now there's a rethink on whether you need a minimum experience at the bar to actually join the judicial service. So Millers, these are thought processes, and we are part of the system where we want to better the system for the future. Because these disputes have arisen only because there was some lack of perhaps Millers adequate attention to this detail. That's all there is to it. If your lordships direct, the High Court will apply whatever standards your lordships lay down. It is, if your lordships believe that this is the correct thing to do, these are all, because we are all part of the system, because that's all. And it will help in the future to say yes, and it will help this committee also, which is set up, Millers. If your lordships decide that yes, this will be the past, and from here 4-point roster has to be implemented, so this dispute till now will come to an end. And say from 1st July 26, when your lordships, the Supreme Court judgment should be coming into force from 1st April or 1st July, whichever date, then it will be easier for the registry to work out this 4-point roster. That's what I believe. But these are things which nobody can predict.
Yes.
Millard.
So let us see.
Yes, Millard.
We'll restrict at that. In
Yes.
case we require your assistance at subsequent before it's wound up, we'll
Yes.
call upon.
No, please, Millard. It's always a pleasure. I keep watching it online without coming on screen, Millard, but I'll be happy to assist, and I'll come back on this pleadings part, your lordships, by way of written submissions.
Yes.
Very, very grateful.
Your written submissions must also advert to
Yes, Millard.
how this 4-point roster
Yes.
vis-a-vis quota and change in quota is to be reconciled.
Change in quota. 4-point roster. Lordships had said how the written submission should take into account the 4-point
Reconciling of
reconciling of.
change in quota vis-a-vis cadre strength.
Yes, Millard.
And how are you, and when this 4-point is, and when you are going to implement this.
Right, Millard. I'll do that.
So there will be a mismatch, at least in the interregnum.
Yes, in the beginning there will be, Millard. Yes.
So one of the 1997, there is a central government notification which deals with such reconciliation and submits that though it is cadre based,
Yes,
in the interregnum when a new roster comes into play,
right, Millard.
the starting point of the new roster, before that the vacancy will have to be filled up in different proportions so that it comes up to that proportion of the entire quota. And then you start working the roster point. Now, suppose you start working the roster point when the quota is not adjusted.
Yes, Millard.
Then it will not work out.
Absolutely.
Now, if you are saying there is an increase in quota of
Yes.
50, 25, 25, let's say.
Yes, yes, Millard.
Then you work out what are the posts.
Yes,
But
Millard.
as on date,
Yes.
there will be an imbalance.
There will be, Millard. It will remain for some more time also.
So how are you going to reconcile this imbalance before you start working of the roster point? Is that the vacancies that will occur
Yes,
now will have to be done in a different proportion perhaps.
Yes.
Till you finally start putting into effect the starting point of the roster.
4-point roster.
So how is this reconciliation? If you have any suggestions, think about it.
I'll apply my mind to it, Millard. I'll apply my mind to it.
Yes.
I will ask the learned amicus also if he had anything. This is a friend of mine. I'll ask him what
Yes.
what was weighing in the what is his suggestions. I'll try to get that material.
Yes.
It's really important to see the material which was placed before lordships in all India judges, on the basis of which the lordships decided that how this should be worked. Because from the judgment, it does not look like this hiatus has been taken into consideration.
Correct. That what I find, if you look at
Yes.
the direction,
Yes.
now there's a direction to redo the quota.
Correct,
The
Manoj.
the proportion have changed.
Changed.
So when you say implement the 4 point by saying two promotees, one direct recruit, one competitive exam,
Yes,
the
Manoj.
point of implementation of the starting point
Yes.
cannot be in the
Yes.
existing existing vacancy.
You are
You'll have to,
absolutely right.
that reconciliation how to be done.
Yes.
Perhaps we may have to give some suggestion so
Yes,
that
Manoj.
the committee which is now going to do the rule may
Yes.
keep in mind. Just apply our mind to that.
I will do that. Yes, I'll do that. I'll get the material which was also available on based on which the Supreme Court, Honorable Supreme Court has said, so that I can get some guidance on this. I'll
Yes.
do this in the next 3-4 days. I'll do it.
Yes, yes, yes.
But in my respectful last submission, in my respectful submission, it will help if the cadre strength is frozen by a judicial determination by your lordships. That is my personal submission to your lordships, going beyond what the instructions are or whatever the client may say. It is very important that we should know the cadre strength of our own judicial service. That's very important. That's my respectful submission.
Now the other observation is
Yes,
now
Manoj.
this exercise has to be done by the employer.
Yes, Manoj.
They having committed any lapse,
Yes.
if unless the cadre strength is definitive,
Yes.
mere addition of quotes may
Yes.
not be a substitute for adding to the cadre strength.
Absolutely, Milos.
Now,
Absolutely.
for instance, there are some posts, some courts that are set up temporarily for the purpose of a trial. Let's
Yes.
say Jayalalitha's,
Yes,
uh,
Milos.
Kumari
Yes.
Jayalalitha's trial.
Yes, Milos.
Now, no doubt there may be an addition of a court, but you
Yes.
can't add it to the cadre.
You can't.
One. Two, while you are defining a cadre, you
Yes.
must say what is temporary, what is
Yes.
permanent,
Correct.
whether there is anything like a temporary component of the entirety of the cadre. The
Correct.
Karnataka Civil Services rules
Yes.
does refer to temporary, permanent, etc. So
Right.
this, unless the cadre is definitive,
Yes.
the whole thing will collapse. One.
Absolutely. Absolutely.
As long as it is not quantified,
Yes.
ad hocism will come to play. Prima
Yes.
facie.
Absolutely. Lordships are right, Milos. On that, there is no prima facie view, Milos. Your Lordship's view for and me can be prima facie. But absolute certainty should be there. And Milos, if there is any increase, it should be publicly notified that, yes, I have increased the cadre strength and so is the cadre strength.
Yes.
Milos, it happened in Delhi, Milos. What happened, Milos? Just to give an example. Suppose, Milos, your lordships have 4 officers in the Legal Services Authority in Delhi, Milos. I represented Delhi High Court in the matter. There were 4 officers which are sanctioned available posts in the cadre strength, which have to be one member secretary of state legal services authority, etc. There was a large pendency, Milos. There is a local court called Patiala House in Delhi. The Honorable Chief Justice has set up 2 additional courts, court of 5th additional session judge and 6th additional session judge. And 2 officers who were working in the legal services authority were posted here to do the function. So as your lordship rightly said, I have set up 2 more courts. Somehow I have managed space, I have created one courtroom and asked them to function. But that doesn't mean that now 2 more posts are become available. That's how one has to think about it.
Let us see.
Yes, my lords. Grateful to your lordship.
Yes, who else?
For the state, here for the state.
Just 1 minute.
Is it very for whom?
Yes, Milords, for the state, our role is limited in this, Milords. But
No, no. Mr. Gaurav says that you are
No,
the
no.
most important part of it. That you are the one who holds the purse strings. You are the one who's the determinative factor.
Please.
And that you will have a final say, though it's the High Court with your consultation.
Please, Milords.
So now what is your view? We like to hear, including regarding cadre strength.
Let's directly straight away coming to the issue of cadre strength, because that is where, Milords, the government's role will come into play. Now, Milords, here the confusion that has arisen is on account of the fact, Milords, that the rule did not specify a particular number, and the High Court, Milords, has taken subsequent notifications into consideration, creation of posts and creation of courts, and all that have been consolidated, Milords. Insofar as I would refer to the High Court, Milords, as a cadre controlling authority here. Though, Milords, insofar as under the allocation of business rules, the law department is involved and the DPR also is involved. Because Bhagwat sir was mentioning specifically about DPR, but constitution of the courts, Milords, and post comes under the law department. I will point out. Yeah, law department. Creation of post, creation, Milords, it is the law department, Milords, which constitutes the court. I will take, Milords, to the allocation of business rules. But, Milords, insofar as the stand, Milords, that the cadre controlling authority, that is the High Court, has taken into consideration, Milords, with regard to the memos they have filed, Milords, and the subsequent notifications on the basis of which they have calculated the cadre strengths. That is, they have Milords, the memo dated 8/9/2025.
Yes.
No, it's in this memo, if my lords may see, it's the memo itself, my lords. I'll just read the memo. This honorable court, by the order dated, my lords, get it, please. The memo.
Yes.
This honorable court, by the order dated 2/9/2025, had directed the appellant to produce copies of all the notifications showing the cadre strength of district judges over the years. In compliance of the said order, the appellant is herewith producing a statement showing the cadre strength of district judges as on 1/1/2003 and subsequent increase decrease in the cadre strength due to creation abolition of courts posts during the period from 2003 to 2016, along with copies of the relevant notifications, government orders. Now, my lords, may kindly see the next page. Statement showing the cadre strength of district judges as on 1/1/2003 and subsequent increase decrease in the cadre strength due to creation abolition of courts / posts. Serial number 1, my lords, notification law LAW 165 LEC 2001 dated 15/2/2002. My lords, before that they say as on 1/1/2003 cadre strength is 155. That is what they have mentioned. Then subsequently, my lords, they have produced the copies of the notifications also. By the serial number 1 notification, my lords, they say number of courts posts created abolished is 1. So cadre strength gets increased by 1. Similarly, my lords, they have given notification serial number 5. My lords may kindly see it has 10 posts or courts that have been created, and they have taken into consideration 169 posts. Now, my lords, this is the calculation, my lords, by the High Court, that on the basis of which, my lords, they have calculated the cadre strength, and they have operated, my lords, the quota, that is the DRPR as well as the other quota, my lords, on the cadre strength. Now, my lords, my submission is that insofar as the state is concerned, we have no objection to the High Court, my lords, taking cadre strength, my lords, in this manner.
What is the legal position regarding cadre? Under the KCSR, it is the state that has to define the cadre, isn't it?
Please, my lords, under the KCSR, my lords, under KCSR, my lords, what happens is this.
So now,
please, my lords,
the recruitment rules say other rules apply.
Please.
Other rules including these, and where is cadre defined? Cadre is defined, where is it defined?
Lords, cadre is defined, my lords, in the KCSR as it is cadre, my lords, is a strength of a unit. Strength of a service sanctioned as a separate unit.
So if that is so,
Please, my lords.
then the notification must be by whom?
With regard to the determination of the cadre strength.
Yes, cadre.
Lords,
Be by you, prima facie.
Lords, prima facie, my lords, what happens is this: when a cadre and recruitment rule is published, we will have the designation of a cadre. For example, my lords, it could be a district judge, junior scale, or district judge, or I will take any other post. My lords, I'll take Karnataka Administrative Service junior scale. Now, the number of, it will mention the pay scale. It will also mention the number of sanctioned post. Now, that sanctioned post that is mentioned in the rule, my lords, is not sacrosanct in as much as even without modification of the rule or amendment to the rule, by virtue of government orders, my lords, we can increase or decrease the cadre strength. That is the position. In fact, my lords, one rule my senior had read with regard to the increase and decrease of the number of posts under the amendment to the Karnataka Civil Services Act. Lords, what happens is this: cadre, if cadre strength is actually provided in the cadre and recruitment rules itself, then that will be the cadre strength. And if there is an addition or modification to that cadre strength, it will be by virtue of an executive order or amendment to the rule. Now, if it is silent, what happens is, suppose, my lords, there is a employer, a particular department. Now, department, my lords, there is a post outside the cadre that is not created, my lords, in the C&R rules. I will just take an example. But the idea of a post, a cadre post, my lords, is that there is a financial sanction to that. The entire idea, my lords, of a cadre post is that it belongs to a particular cadre. There is a financial sanction, my lords, that is attached to that. When it comes to a financial sanction, my lords, and creation of courts, creation of posts, permission to create number of courts with certain number of post, my lords, that is where the state government's roles come into play. Now, but for the purpose of maintaining the quota, how High Court goes about considering the cadre strength, if, my lords, it is written without any if it is provided in the rules, my lords, there is no dispute. Unfortunately, that is not provided for. High Court has taken into consideration, sir.
Notify the cadre strength. Suppose there's an increase, there's a decrease.
Please, my lords.
Suppose, let's assume there's an increase and decrease. Must there not be at least a notification stating after this increase, this is the cadre strength? Let's assume 10 people have been removed, 10 people have retired.
Please, my lords.
Right? After that, the shuffling takes place. Must there not be a notification regarding the change in the cadre strength? The quota is going to work on the basis of the cadre. There must be some definitiveness in the cadre strength. Unless the cadre strength is quantified, definitive, objectively verifiable,
please, my lords,
the quota will always be in dispute.
Please.
If the cadre is certain,
please,
then you can definitely work out 60, 25, 15, 25, whatever it is.
Please, my lords.
Now, this action of quantifying the cadre,
please,
in the existing system,
please,
if the KCSR would be applicable,
please,
lies with the government, isn't it?
Let's, in so far as a High Court it is concerned, it is only about financial sanction, lords.
No, how do you say that?
Let's,
now is the KC, I'm just saying, I'm
please,
just putting it, we have not made up our mind.
Please, lords.
But Mr. Bhagwat pointed out, prima facie, we feel that that may be the position,
please,
that the KCSR would be applicable.
Let's,
the recruitment process may be within the sole control of the High Court.
Please.
No doubt about it. Still, notification would be by the government finally. But insofar as other aspects are concerned, including the cadre, prima facie, the KCSR says what is the cadre. KCSR further goes to say what are temporary, what are permanent. So that determinative authority would be the state, though in conjunction with the High Court. That we don't dispute. That the High Court has a role, nobody disputes.
Please.
Even Mr. Bhagwat concedes, yes, the High Court will have a role, but the authority to quantify it under the existing legal framework would be the state.
I don't think KCSR per se will apply. KCSR only defines the word cadre. Cadre is defined in KCSR, but it is the Karnataka Civil Services Act that applies insofar as the creation and abolition of posts is concerned. It is not the KCSR. KCSR does not talk about creation and abolition of posts. Maybe it uses defines what is a temporary, what is a permanent post and other things. And it talks about other regulations that it applies to. KCSR per se does not deal with the creation of a cadre. It is the Karnataka Civil Services Act which deals with the creation of posts. Constitution of cadres, my lords, is under the Karnataka Civil Services Act. If my lords may see that, I think Bhagwat sir was referring to that. Kindly see the Karnataka Civil Service Act for a moment.
I showed your lordship point to him in judgment. Karnataka Civil Society, no application at all as far as judicial service is.
Notification also says page 18. Four rules. 4 rules, page 16. This says 50%.
One such notification I have produced is 33/2001. It is along with the enactment. And 83 rules also will not define what is the cadre.
Now, insofar as conditions of service,
Please, my lords.
it would be under 309.
Please.
Subject to nothing inconsistent with 320, 333, 233, 234, 235.
Please.
Isn't it?
Please, my lords.
Then so far as conditions in service, it would be the state that has the final say.
Please, my lords.
Now, where do you get this quantification of cadre? Let us, what according to you is the power? Who is going to quantify the cadre according to you?
Lords, if my lords may see section 3, my lords, of the Karnataka Civil Services Act for a moment. Section 3.
Act ಕೊಟ್ಟಿಲ್ಲ.
Act.
ನೀಲಿ ಕಲರ್ ಬೈಂಡಿಂಗ್ ಇತ್ತಲ್ಲ, ಬ್ಲೂ ಕಲರ್ ಬೈಂಡಿಂಗ್ ಬೇಕು.
My lords, get it. Subject regulation of recruitment and conditions of service. Subject to the provisions of this act, the state government may by notification make rules specifying the different category of posts in different branches of public services of the state, the total number and nature of posts in each such category, and the scale of pay admissible to each such category. So, but this applies, my lords, insofar as different branches of public service of the state. The word used is different branches of public service of the state. Now, my lords, suppose in all the cadre and recruitment rules that are framed under section 3, there is a specific, there will be the category of post, there will be the total number of posts that is sanctioned. And it will also specify whether it's a temporary or permanent post. Permanent post or temporary post, my lords, can also be taken into consideration for the purpose of determination of cadre strength. Now, if suppose under section 3, my lords, there is a C&R rule, and C&R rule says there are of a particular cadre of posts, there is 100 sanctioned posts. Now, my lords, what happens is by virtue of executive orders, when there is an increase in post, suppose we increase post, my lords, by we are saying that 10 more posts are added because there is a financial sanction to that. 10 more posts are added, though there will not be an amendment to the C&R rules per se. Like C&R rules is not amended. When next amendments takes place, maybe the number can be amended. But suppose we don't make it 110 also there, but still there is a separate executive order where there is a financial sanction for the number of posts to be added, that will include the cadre strength.
Example, 2 additional courts are set up.
Please, my lords.
One for Jayalalitha's trial.
Please.
2 for Dandupalya, trial of Dandupalya.
Please.
2 special courts.
Please.
1 for stamp Telgi case.
Please.
Is the 3 addition ipso facto addition to cadre?
Let's there are 2 submissions, my lords, that I want to make on this. One is, my lords, High Court has taken into consideration that to be added for the cadre strength. High Court has added those posts, my lords, even while increasing the number of posts. That may not be per se wrong. I would put it this way, my lords. If they have taken it into consideration and that post continued subsequently.
See, we are again going to the point that there must
Look,
be some definitiveness in the.
No, my lords, I'm coming to that. I'm making the alternate submission.
No, then are you? So your argument appears to be.
Please.
That what the judgment of Justice Anu Shivaraman,
please,
senior judge,
please,
the interpretation of cadre,
please,
saying that the notifications can be taken note of, is sufficient. Is what's your stand?
My lords, that is sufficient, my lords, because that is an inter partes litigation with the High Court, and the High Court stand has been accepted. That is sufficient. But if you take it on first principles, because I have extensively argued the matter appear on service side also, my lords. If you take it on first principles, it might be a bit difficult to countenance that argument. But the fact that when that court was created, my lords, for the trial of a particular in a particular matter, technically, my lords, it partakes the nature of a temporary post. It is just the court is sanctioned. What we take into consideration is there is a sanction for an administrative setup of a court where you have a physical setup of a court there. The finance for the purpose of that additional court is sanctioned. But what you do is you don't appoint a new person there, but you send a person within your cadre strength to man that post. That is what happens. That is what happens. So you are per se on first principles. If you break it down to the first principles, it might not be. I can say that it might not be an ideal situation, what they have, how they have gone about it.
You can take your stand forthright.
Please.
You don't have to hesitate, because finally this is not adversarial.
Please.
Finally, what we are seeing that the effort is to see that there is some system in place. That's
Please.
all. It's not that X is right or Y is wrong. So in that sense, we want you to, in that sense, we are thinking about, we have not made up our mind.
Please.
So just like what cadre strength, so we are thinking still that mere addition in posts may not ipso facto amount to increase in cadre. Now the reason why we are just thinking about it is that there must be periodically a notification stating what is the cadre strength prior to any process of promotion, filling up, etc., because it has an implication on the quota. If there's no certainty of the cadre when you are going to do the promotions, definitely there's going to be place for litigation.
Please.
So far as we don't know whether the promotions are being within their quota or outside, etc. So keeping that in view, what would be your argument? One, vis-a-vis the notifications here and existing manner of interpretation of cadre, which has been voiced. Two, way forward. Both you reflect and tell us. Please. Now, the two opinions, there appears to be some difference amongst the two opinions rendered, wherein one opinion is that the cadre must be by way of a notification by the government in terms of the procedure. The other view appears to be the term cadre is flexible and depends on the needs of the employer, and the sum total of the notifications of additional courts can be taken note of. The High Court, on the other hand, it has now come up with their memo and a bunch of notifications stating that this is what the cadre strength is. Otherwise, definitively on record, there does not appear to be anything that is certain on the cadre strength.
It is not on record.
Correct, isn't it? So, from the existing views and the way forward,
Please.
what according to you would be the ideal situation, considering that High Court may have primacy in recruitment,
Please.
while conditions in service is something that is left to the under 309.
Please.
How do you balance this recruitment seniority vis-a-vis cadre strength, role of High Court and that of the government?
Please. That's one submission at the outright that I could make, my lords, is that if
you can think about it also.
Please, please.
It's not that we want an answer today.
Please.
But what we are saying now, the reason why the premise on which the petitioners approached the court was that there was an excess in the quota.
Please.
And they said that if 139 posts were the increase in quota, giving so many posts to the promotees would be in excess of the quota. That is the premise under which they have come.
Please.
So in that context, cadre requires to be determined. The two opinions have a difference on how the cadre is to be construed.
Please.
So keeping that in view, you can.
Please, that's when usually what happens is under our High Court rules, when there is a divergent opinion, it would have gone, my lords, before a third member, judge, my lords. But now, since the Honorable Chief Justice has constituted a full bench, a different view also can be taken, because usually when there is a third umpire judge who has been nominated, my lords, to be the third judge, then either the view has to be towards one or the other side so that there is a majority. But now a full bench having been constituted, my lords can take a totally different view, my lords, from either of the opinions that have been rendered. So that is available, my lords. But insofar as, my lords, in the allocation of business rules, I just wanted to point it out, my lords.
Yes.
Is that part of the lord? Page 40, lord, 44. Page 46, lord, under the head G.
Just hold on.
Rule 17, creation of
The other department, finance department.
Rule 17 of the business strategy. 17. Which transactions? What are those?
Simple question. Is there any other procedure to increase the capacity of the land? There's only
No department should create it.
so far, how many notifications are issued for the increasing? I was writing it.
Yes, district judge, city civil court, first edition district judge. Tomorrow is high court, you send me to the special court, created.
Doesn't amount to, that's what he said.
So, Bhagwat says, is that when the cadre strength was sent for a particular object, with all the anyone getting common based on the first. The process high court. The promoter notified the cadre. How you will annul that?
2001 Anantilla.
That does not mean if the airport there is not available, every appointment is illegal without a card.
Here, we refer to cadre strength. They refer to cadre. Entry level. Temporary posting is entry level.
All this is entry level.
I have framed it. No, some posts are created which has to be mandated by principal district judges. So how can it amount to increase in the cadre strength?
That's why.
Is placed before the court only notifications are received so far. Notifying the cadre strength or increase or decrease in the cadre strength.
Till date, we
Please,
just want to know, is there any notification by the, which you can cross check?
please,
Any notification indicating the cadre strength by you?
please.
Whether there is any notification indicating the cadre strength by you,
Please,
that you just verify.
please,
It's a
because-
matter of record.
please, I'll do that.
Page 15 not, that is the
Bhagwat sir
last
was
notification,
Bhagwat
which
sir
is
is
not
the-
disputed.
I will verify with the minutes.
Let them verify.
Minutes.
Bhagwat has given that.
But we'll verify it officially minutes from the department
So-
and place it on record.
So Mr. Bhagwat stated that except for that one notification,
Please,
there is no other notification by the government regarding the cadre strength.
please,
That you verify.
please.
But I am not saying what a temporary post shall not be excluded. It can be included. I am not saying that. I am not on any point.
That's-
From 2010 till 2015. How many notifications?
So you can take any time after 2010
Please.
onwards, any notifications
Please,
by you, by the
Please.
government
please,
regarding the cadre strength.
Kediston. After 2010 minutes or from the day one?
After 2010.
Then
should be-
idea, I should be,
We are not going to go too further back.
please,
No,
minutes.
Lecture P is given by the High Court itself up to 2010. That's why I pointed out. to you.
Correct. So after 2010, you
Yes.
Please, minutes.
cross check and take a stand.
I'm not
Yes.
disputing that not at all. Nobody can dispute. High Court also says yes,
Yes.
but I'm not on the point not favor to anybody.
Let's, in the allocation of business, my lords have the allocation of business
Yes,
rules minutes. Let's see, if my lords may see in the, where what senior had pointed out, Bhagwat sir had pointed out with regard to the allocation of business minutes to the Department of Personal and Administrative Reforms.
Yes.
Notes in that G, my lords, page 46. High Court and its administration, service matters relating to High Court judges and district judges. But if my lords may see, while having this entry, let's entry under schedule 11A, my lords, Law Department. That is at page number. Let's page number 659. It starts at 59.
50.
It starts at 59 minutes. Law Department, litigation in that B, judicial, under that, my lords, serial number 11. In B11, administration of justice, constitution and organization of all courts except the High Court. So this is where, my lords, the source of power is, because if my lords may see all the notifications that the High Court has produced, they're all issued by the Law Department and not by the DPR. Though, my lords, there, how Law Department comes into play is with regard to the administration of justice, constitution and organization of all courts. Let's at the outset, my lords, one submission with regard to the basic concept, my lords, between a cadre strength and a cadre post. Let's cadre, just the, if we count the cadre posts, for example, cadre posts are those posts, my lords, where a person belonging to a cadre can man that post. That is called a cadre post. For example, my lords, when a court has been created with regard to, for a special court has been created, a district judge, it says district judge post has been, will occupy that, will head that bench. So will head that court. So that post, my lords, becomes a cadre post of the district judge. But just because there is a cadre post, the cadre strength on first principles is not addition of the number of cadre posts. That is one basic principle, my lords, in service law. Just because you add up the number of cadre posts does not make it the cadre strength. For example, my lords, in IPS, insofar as DIGP posts are concerned, it is a level 13A post. Lords, total number of cadre strength today in the state, because recently we had a litigation on that, the cadre post, my lords, is only limited to 33, but the cadre strength is more than 100. So they're manning different posts, my lords, across. So the pure cadre post, my lords, for a DIGP level officer, my lords, under the All India cadre strength regulations, my lords, is only 43. But the number of the cadre strength is different. Cadre strength, my lords, basically connotes a financial sanction to fill up that post. That is the concept, my lords, of a cadre strength. So in that manner, High Court having taken into consideration, my lords, I have my view, but I'm still saying that High Court might not have been wrong while making a calculation, while operating in that manner. But the question is, if it is wrong on first principle, if while operating a quota, my lords, you take a certain number of posts which is workable and you operate it on that, then, my lords, it cannot be found fault with. Somebody cannot say, no, you remove this so that I can go up. It is not a litigation, my lords, with regard to whether you reduce the number of posts and therefore a calculation of quota becomes excess and therefore I go up and you come down. That cannot be how it has to be looked into. It has to be looked into, my lords, on first principles per se first and thereafter applied. But if it has been operated in a particular manner by the High Court, by taking into consideration even a cadre post to include a cadre strength, for example, my lords, that additional post. And one more example that Bhagwat sir had pointed out is with regard to a post in the Lokayukta that is manned by a district judge, and, my lords, in the Supreme Court also, even that have been taken into consideration. If they have taken that into consideration and that is added to the cadre strength while calculating, and then the quota is operated thereon, there is no prejudice that is caused to anybody.
It's not a question of prejudice.
Please,
we're on a point, we're on a legal point.
Please.
The whole litigation premise,
please,
of the petitioners appears to be, like, if we look at the petition,
please,
their heartburn is that there is excess of the promotees are in excess of the
please,
quota.
Excess of quota.
So now the quota one is dependent on the cadre strength.
Quota is dependent on cadre strength.
Here it becomes a.
It is only cadre strength, not on the basis of vacancies.
So now we are on that point.
Please.
Of what constitutes cadre.
Please.
What is the procedure to be followed?
Please.
One is insofar as the existing dispute. Two
Please.
is the way forward that this does not repeat.
Please.
Now, while one, it's not so much adversarial, as Mr. Gaurav pointed out.
Please.
We are more on trying to see that there's more certainty. We avoid disputes because we can't spend time. Judges must not spend time in courts.
Please.
Isn't it?
Please.
Two, we must try to reduce any possibility of ad hocism. Three, certainty.
Please.
Four, transparency. Towards this, how is it that we go forward is one part.
Please.
Two, insofar in the context of the existing allegation that there's a breach of the quota.
Please.
So your view is that the construction of the High Court of addition of posts must be maybe taken as a cadre strength. That's what you're
No,
indicating.
I'm saying on first principles,
That is the reason for saying so. And it is wrongly premises High Court procedure. Why you want that it should not be unsettled, and why Proceedings will not cause notified. What is how you substantiate that?
So what is your stand regarding how the High Court is construing the cadre strength?
let's
What is the legal, what would be the correct position according to you?
let's the stand, my lords, of the insofar as the state government is concerned, we want to say that High Court, having taken into consideration addition or deletion addition of some courts as part of the cadre strength for the purpose of calculation, my lords, might not be per se wrong, but on first principles, that insofar as an officer of the court I am submitting, on first principles, that may not be the correct position. But if they have done it up, for example, my lords, I'll just give it this way. My lords, let us assume we had 90 posts, my lords. We had 90 posts. 10 new posts were added because of addition of courts, or 10 addition posts they have taken into consideration. It has become 100. Now, while you're operating any of the quotas, that is a direct recruitment quota or any promotion quota, if you take into consideration 100 and you have operated it in that manner because you have financial sanction for those 90 posts, technically, if you go by the definition, it may not come into the, it may not fit into cadre strength because it is just a temporary post that has been created. But while either operating the promotion quota, it is not about they giving a justification today. It's about when you operated it on that day, whether you added it to that. If you have actually operated it and the operation has come about insofar as even a direct recruitment post has been filled up on the basis of that quota, then now we cannot say that you shrink that quota, only disregard that post. Maybe for future, my lords can lay down the law. But I'm not saying High Court will not be per se wrong, my lords, in taking that into consideration is my respect.
We'll consider. Yes.
Lords, I will place on record, my lords, the notifications. I will ask the DPR, my lords, as well as the law department to place on record, my lords, if anything is available, my lords. And any other, my lords, assistance, my lords, from the state government, my lords, we are available. I'll just place it on record, my lords, insofar as any other notifications that is required.
Second point is,
Please, my lords.
in the context of the new 4-point roster,
Please, my lords.
how are you going to reconcile the change in the quota percentage? So now the 50, 25, 25, there is that change by virtue of the latest judgment of the apex court.
Please, my lords.
That is a change from the existing percentage.
Please.
So when you're going to implement the 4-point roster,
please, my lords,
and this change in quota,
please,
how is the reconciliation to be done? Suppose we were to start, let's assume now we are going to start some recruitment. Could we start with the 4-point roster as of now, or there must be some reconciliation between the change in the quota? Think about it and you can give your submission so that
please,
we may take note of it.
Please, my lords.
You can file a small written note.
Please, my lords,
on this.
Lords, there'll be, insofar as I'm concerned, my lords,
yes,
the state has not per se taken a stand in a particular manner in this case from the pleadings, my lords, either before the division bench or before the learned single judge. It has been a litigation, my lords, between the direct recruits and promotees, and my lords with High Court, my lords, as the cadre controlling authority. So officially, my lords, I will take the stand of the state government insofar as this, but I had spoken to them regarding these notifications, and therefore the stand was placed on record. Apart from that, my lords, as an officer of the court also, if there are some views, my lords, I will point it out, my lords, as my submissions.
yes,
Just to assist the court, my lords.
yes,
Not as the official stand of the government. Whatever is the official stand of the government, I'll state it that way.
yes.
And if there is anything, I will place it on record, my lords. If there is any submission, my lords, from my side, please.
Yes.
Please, my lords.
Government has to say regarding notification 24 to 2006, where apex court legislated the law 15 plus law 10. DPR is issued that. It is not law department. Now kindly see the notification.
No, law is about if a court has to be if a new
No,
court.
I'm not on point. 24 to 22 for 2006, my lord. Kindly see, 25% creation district judges shall be reserved for selection grade. It is the DPR which has issued it.
No, that is a DPR.
Yes.
Some DPR.
And the government is abroad. Government has to say something about it because my lord is laying down the law.
Let us see, let us see.
Which I have given.
Let us see.
Otherwise, my lord, vacuum will be created. My lord has to say something about it.
Just one, either you can answer it now or think about it and revert. Mr. Bhagwat says that the district judge cadre would have to have three difference: one entry level, selection grade, and super time.
Please.
And it's Mr. Bhagwat's contention that though this aspect has not been touched by the courts, however, super time is a different cadre, and the quota must be in reference to only entry level. You can think about it and make a submission on that.
Please, my lords, I will consult the
He's
DPR.
relying
and
on that.
But 83 rules also create super time scale.
Let us
Kindly
see.
note it.
Let us see. We have an open mind.
Please.
But prima facie, it's a contention that is raised now.
Please.
Yes, lord.
Whether-
I already told lord. I
Whether
admit that.
entry level, selection grade, and super time are part of the same district judge cadre or layered as he's submitting. That's something you can make a submission.
Please.
He's relying on some memo.
Please,
I have given.
I'll take that.
I have given. I have given to them. Copy ಕೊಡಿ. ಇನ್ನೊಂದು copy ಇವ್ರಿಗೆ ಕೊಡ್ತೇನೆ.
Yes, now who else? Who else? Yes.
Rajgopal my lord will reply to their argument. For that, my lords may have it on Monday. He has some other tomorrow and day after.
On Monday.
Probably High Court has to explain.
Yes, there is one
Because it is
problem.
the-
Mr. Naganand has undergone surgery. So after Mr. Rajgopal concludes, senior will argue. Madam.
But I have one reservation, lord, because they are not. But they are not filed reply. Only High Court has filed reply.
No,
Kindly appreciate it.
let us see. We'll hear. Finally, we'll make up our mind. Mr. Naganand will be in a position to appear when?
My lord, next week, any day next week, after Mr. Rajgopal and Mr. Sondhi conclude, we'll argue towards the end.
No, no,
At last.
correct. So now on Monday.
Today we are almost.
Monday. So Monday 2:30. And whatever Mr. Rajgopal will start, isn't it? And then it should be two. It's only a reply. We can't enlarge the scope now. One, two. You must file your written submission in advance on whatever you are going to submit. The arguments of Learned Senior Counsel Sri Gaurav Agarwal for respondent number 4.
Respondent number, petition number 4.
For petitioner number 4. Writ petitioner number 4 was heard, comma. Learned additional advocate Ruben Jacob has made preliminary submissions on behalf of the state. It's further submitted that the state would file the written note.
Please.
Written note. Full stop. For reply, Learned Counsel Shri P.S. Rajgopal makes a request through advocate on record. Matter may be taken up on Monday. Accordingly, relist the matter for further hearing at 2:30 on Monday.
Lords, only one submission, Lords, is
Yes.
as an intervener, my Lords, I had filed an application. Lords, I will be adopting, my Lords, the arguments of Learned Senior Counsel, my Lords, Mr. Bhagwat.
Only one Lord's submission Lord's that I would like to add Lord's is, apart from Lord's the cadre strength is concerned now Lord's, which is posed by this honorable court. Lord's, if Lord's the revision has to take place Lord's, it shall not be stopped Lord's at 2016 because Lord's the petitioners have come before the court Lord's exposing their cause Lord's the recruitment that has taken place Lord's in 2016. Lords, we are all Lords appointed in 2017. Lords, from 2017 onwards, or Lords subsequent to 2017, there is no dispute with regard to the seniority. Lords, how it has to be construed, Lords, is there is no dispute at all. Lords, the non-consideration of Lords the cadre strength, Lords the quota rule, Lords, is up to 2016 and till 2017. Lord, I am only seeking, Lords, that it shall not be stopped, Lords, till 2016, and it should be, Lords, extended to till 2017.
1911-2025, up to that, Lord has to. My Lord will remember that 4-point road is introduced only in 1911-25. All high courts are given 3 months' time. All high courts are given 3 months' time to adopt, amend the rules. So up to 1911-25, according to me, my Lord, I am making a my Lord submission at large. My Lord has to say, because Supreme Court said it can't be reopened. Earlier is concerned, you have to adjudicate. Only from 1911-25, within about 3 months, all high courts are given time to not frame the rules. Therefore, my Lord has to say till 1911-2025.
And so far as Lords, the cadre strength is concerned, Lords, whether that could be Lords under Lords Article 162 Lords by exercising the executive power of the state Lords, the cadres Lords, one is cadres are also created and the posts are also created Lords by virtue of the notifications issued under Lords are which is traceable to Article 162. But this honorable court Lords in any number of cases has come down heavily Lords stating that so far as creation of posts are concerned or abolition of posts are concerned, it should be by way of Lords the bringing amendment to the rule itself or to the statute, without which it cannot be done at all. Lords, in a case where Lords the posts are created by issuing notifications, Lords, those notifications were also quashed. Lords, even in many of the cases, Lords, where myself and Ruben has also appeared, Lords, that where the notifications were also quashed and it is categorically stated that it should be by way of the amendment to the rule itself. If that is the case, Lords, if there is no creation of post by virtue of Lords, either sanction Lords by the state government, by publication of notification, or even Lords by bringing amendment to the rule itself, that such and such a number of the posts are created, either at the entry level or Lords in any other posts are concerned. Whether those number of posts Lords created by virtue of an order, Lords, whether that could be considered as part of the cadre strength itself, Lords, is another aspect. Lords, that has to be Lords. I'll make submissions with regard to that, Lords. Keeping open, Lords. So far as the other submissions are concerned, Lords, I fully adopt the submissions of Mr. Bhagwan.
Heard Land Council Subramania on behalf of the interveners as well. In one sentence, the High Court has filed a memo. Memo kudu. Has filed a memo dated 11/3/2026, placing before this court the constitution of a subcommittee by notification dated 23/2/2026, whereby the committee has been directed to submit a report on implementation of directions given by the Apex Court in the order passed in WP Civil 1022 of 1989.
1911-25.
All India Judges Association and others versus Union of India and others by its order dated 1911-25. Same is taken note of.